Good afternoon, everyone. Assalamualaikum warahmatullahi wabarakatuh. Selamat siang. My name is Nadir Sahosen. I'm an acting director of CILIS, the Center for Indonesian Law, Islam, and Society at Melbourne Law School. On behalf of our co-host, the Asian Law Center, Melbourne University Publishing, the School of Law at Western Sydney University, and the Center for Asian and Pacific Law at Sydney Law School, I'm delighted to welcome you to the launch of the Melbourne University Publishing Series, Asian Law and Society. This series is more than a collection of books. It is a platform that captures the depth, complexity, and diversity of law and society across Asia, from West Asia through to East Asia. It reminds us that law never stands alone. It is always woven into politics, economics, culture, and religion. Now, you might ask, why do scholars still publish books in an age of social media and artificial intelligence? Well, because books do what tweets and algorithms cannot. They go deep when the word goes shallow. They hold nuance when everything else becomes a headline. They give us space to think, to argue, to connect ideas across discipline, and they endure. That is exactly what the Asian Law and Society series offers: scholarship with rigor, courage, and lasting value. Drawing on anthropology, sociology, law, political science, economics, history, and more, the series tackles issues that matter: corruptions, judicial reform, customary law, medical legal dilemmas, and religiously influenced legal traditions. These are not abstract debates. They shape the daily lives of millions across our region. We are especially proud that three remarkable books have already been published. Today, we celebrate the work of Professor Simon Butt, Professor Todung Mulia Lubis, and Dr. Matthew Bush. They are the scholars and authors whose contribution set the tone for what this series can achieve. Their books prove that rigorous, courageous scholarship can speak not only to academics, but also to the wider community. We are fortunate to have all three authors with us today, and we will hear their insights in conversation with Associate Professor Jeremy Kingsley. So today, let us celebrate more than a book launch. Let us celebrate the power of ideas, carefully written, deeply argued, and accessible to both scholars and the public. In an age of noise and distraction, this series reminds us of the enduring values of thoughtful scholarship. So thank you for being here, and please join me in celebrating the launch of the Asian Law and Society series. Now, I'd like to invite my colleague, Dr. Helga Oseger, to deliver the acknowledgement of country.
Thank you very much, Pak Nadir. So I would like to acknowledge the Wurundjeri people of the Kulin Nation on the unceded lands on which I am standing. Because this is a webinar, we also acknowledge the traditional lands of all the Indigenous people on whose lands our speakers and our audience are on. The land is unceded, and we pay our respects to elders past, present, and future. Thank you.
Now it's time for Associate Professor Jeremy Kingsley from Western Sydney Law School to be the host for this conversation with the authors.
Wonderful, terima kasih, and thank you to both Pak Nadir and Ibu Helen. It's an incredible honor to actually welcome everyone today to the official launch of the Asian Law and Society series published by the incredible impress Melbourne University Publishing, MUP. It is an incredible honor because it's taken about almost 6 or 7 years to get to this date. So it may sound like the official welcome is happening now, but the idea hatched for this a long time ago, and it is a real celebration of something incredibly impressive. Not just the three wonderful books, and they are exceptional in their own rights, but also just the fact that we're here and supported by such a brilliant press. I also wanted to thank Silas and partners at other partners at Melbourne Law School, Sydney Law School, and at Western Sydney University's School of Law, and to thank everyone at MUP for supporting us through the past 5 years. And I also want to make a personal vote of thanks to Catherine Taylor from the Asian Law Centre and Silas for sort of putting this all together. So our series aims to produce outstanding research manuscripts that showcase the rich and nuanced scholarship on the interaction between law, governance, and culture across the Asian region writ large. And we're talking from Beirut to Tokyo, from Istana to Jakarta. This could not be a more consequential time to produce these works. At a time where riots have rocked Nepal and Indonesia, where India is in a tariff war with the United States, and where geopolitical tensions are simmering in the Taiwan Straits, we can't ignore our region. Our region is at the center of geopolitics today. For Australia, we can't ignore the 280 million strong nation to our immediate north, who are a socio-political, religious, and, with some TLC, a commercial power. For instance, Indonesia is heading towards being one of the top 5 economies in the world, leapfrogging Australia within the coming 20 years. Nor can we understand India without recognizing the cultural underpinnings when engaging with over 2,000 different ethnic groups that underpin the world's largest democracy. All these challenges weave in and out of statecraft, constitutional laws, and regulatory structures. In responding to these situations, we need to understand the contextual and empirical realities. And this knowledge can't be held within a small clutch of experts. They need to be publicly debated, and they need to be part of public discourse. Consequently, this book series seeks to both have an academic audience, but also a wider readership. Books in this series are based on original research, and as Panadir said, we cross the disciplines. In an academic sense, this series will serve as a tool to showcase research excellence on scholarship of Asian law and society. And it's at this point that I think it's really appropriate to introduce our 3 authors who are going to be here today and engaging in the forum. This is really, let me start with Bapak Mulia Lubis, who's arguably Indonesia's most highly regarded advocates, alongside also formerly being the Indonesian ambassador to Norway, and one of Indonesia's leading supporters of Lembaga Bantuan Hukum, or the LBH, which is the legal aid foundation, which is supported and led for decades, longer than I think Pamulia would like to say. So a real honor to have Pamulia. I'd also like to introduce Professor Simon Butt, who is a great friend and leading scholar of Indonesian law. His work on the Indonesian Constitutional Court, and in his book in this series, which considers court dysfunction and the sort of the role of corruption in eschewing the situation, has really become a sort of touchstone from understanding how the nuances within the functioning of the Indonesian legal system. And finally, and not least, is Matthew Bush, an Australian public servant, whose book in the series sheds light on how we can understand and learn from the Indonesian bureaucracy at a particular point of sharp tension and pressure, and doesn't just dismiss the Indonesian bureaucracy or stereotype it. So a real accomplishment in finely grained understanding of the statecraft in our nearer northern neighbour. So now let's hear from the 3 authors. What we're going to do today is we've given the authors 3 questions Each of the I will go through each of the questions in sort of process. I'll tell the authors the order of proceedings, and then the authors will spend just 5 minutes. 5 minutes. I'm putting my hand up for 5 minutes, making it severely clear that it will be 5 minutes. I'll to give an answer to that question. In the first question, just so the authors know, Parmulia will start the answers, the response, then Professor Butt and Matthew, you'll round out the responses. So the first question, and I've slightly changed up the order, is what was the most challenging part of writing your manuscript?
Thank you, Jeremy. Thank you for having me in this virtual book launching. I wrote my manuscript during the COVID time when I served as an ambassador of Indonesia to Oslo, Norway. And at that time, I had already several names to be interviewed for my book project. Yeah. But again, no one could travel under that circumstances at the time. Norway closed their airports. Yeah. No one could travel. Yeah. No one could come to Norway. And so I had to rely on digital conversation with all my resource person, with all my contact person in Jakarta. So that's not easy because talking to the screen, it's different with talking, face to face. This is one of the challenging problem that I faced when I wrote, my manuscript at the time. So I rely mostly, although I still could connect, with all these people, but I rely mostly on my materials, on my on books and papers that I collected before I travel, before I serve as an ambassador in Norway. So this is the challenging problem that, thanks God, I managed to overcome. Yeah, I managed to overcome, and although, I prefer to have more time, to prepare this book, but again, I wanted to have this book finished earlier because when you got back to Jakarta, you will not have much time, to do your research, to do your writing because of so many engagements, so many commitments. So that is for me, the most challenging part, in writing my manuscript at the time. While at the same time, you see a lot of corruption cases being investigated, being prosecuted, being brought to court. And to me, it is important to finish the project, the manuscript, especially Jeremy, because the weakening process of KPK started in 2019, actually, when Indonesian amended the law on anti-corruption. So I just wanted to bring this to the attention of the public, in my book, that there's problems in corruption eradication after the weakening of the law on anti-corruption. So I think this is a setback that we have to fight back. But again, I think my book would probably serve as one source of everyone if they want to know about what is my take on corruption eradication in Indonesia. Probably I'll stop here, Jeremy.
Wonderful. And that shows you the real curse and blessing of COVID, with people being able to actually sit down and do the writing, but at the same time,
in a way, for me, yes.
Exactly. So you're allowed it. You had an opportunity to do it, but it is alone and I sort of isolated. Pa Simon, what's your response to the question?
Thank you, Jeremy, and thanks for getting me along or inviting me along to give a few thoughts today. I too was working on my book primarily during COVID. And unfortunately, we decided to start renovations at the time just before COVID struck, and suddenly we were living in a house that wasn't ours, and I was sitting on a very, very uncomfortable seat for hours and hours and hours trying to produce the manuscript. So it wasn't just mental anguish that I was encountering on a day-to-day basis. But look, one of the more conceptual problems or difficulties I had with the book, all jokes aside, was writing a critique of a rather famous judge, and particularly his judgments. And the problem for me, the hardest part for me, was that all the law reformers who I spoke to and knew thought he was the best judge in Indonesia. And indeed, he was an important legal figure, known for being clean as a whistle, and eschewing a lavish judicial lifestyle, unlike his peers on the Supreme Court. But his decisions were fairly bad. So I'm talking here about the famous late, great Artijo Alcostar. Now, I would say his decisions weren't just bad, they were quite terrible. He would tend to increase sentences of people charged and convicted of corruption without really giving much evidence in decisions of considering why they deserve to have their sentence increased. There were many cases where his judgments, on a panel of 3 usually, simply added to the penalty without any explanation at all. And he was actually involved in quite a few controversial judgments around the time. So he was renowned for being tough on corruptors, on people convicted of corruption. But he was also on the panel of judges that heard appeals against convictions in the Jessica Wongso cases, the Neil Bantelman case, and also the Ahok case.
So, Tom, can I ask you a question
Yes.
on this point? How did you find balancing the two? Like an idea that someone was actually in a personal sense very ethical, very in many ways an exception to the rule, and then in the same side, maybe
that was what was difficult about it. That was what was difficult about it, Jeremy, because I knew him. I'd met him a few times. I interviewed him for the book, and he was a nice, down-to-earth person who I don't think you could say had a kind of a bad bone in his body. He wasn't he was a genuine person who hated corruption and wanted to do everything he could about it. And so he became, as I said, very popular for having a reputation along those lines. But when it came to reading his judgments and hearing, and I also talk about this in the book, some of the conversations he was reported of having that seemed to indicate prejudgment on his part on the guilt of various people, in cases that then he decided, meant that you can't really conclude that he was particularly impartial or produced well-reasoned judgments. And unfortunately, I came across that tension. I had to write as I saw it, which was, quite critically, but with good reason, I think. I mean, you can't just criticize someone, particularly someone with that type of reputation, without very strong grounds. And that's the nature of academic work, unfortunately. Sometimes you have to write unpopular or produce unpopular opinions. Now, happily, when I mentioned these kind of controversial views to Indonesian friends, some of whom are quite close to that judge, some of them actually agreed with me, which I found surprising because I didn't think I'd find any support there. But it wasn't also designed just to criticize a judge. It was also asking the bigger question, which is, well, what does it mean to be a good judge in Indonesia? And kind of after reading all these decisions and looking at all the evidence, I kind of reached the conclusion that being clean was more important than anything else. And there's no question about his integrity. So yeah, I found it quite interesting, but also difficult, part of the book to write.
Well, thank you. Thanks, Simon. And Matt, what's your most challenging part of writing your manuscript?
Thanks, Jeremy. Yeah, thanks for inviting me along, and also just to associate myself with the acknowledgement of country at the beginning. Thanks for that as well. It's kind of it's fun to get this question from you, Jeremy, because I mean I remember sitting in Bellows Bar at the ANU with you in 2019, probably.
Yeah,
and
it was a long time ago.
And I'm so good about it. And you, sort of told me that I should really think about turning it into a book, and it wouldn't be that hard. And it was basically there, and that was the beginning of going down the path of this. No, I jokes aside, though, I think the hardest thing is just the time period. Like, there's so many sort of peaks and troughs in the process. So I remember in probably 2020 maybe spending like a concentrated couple months really trying to get the book out of my PhD thesis. So this came out of my PhD thesis, which I did at Melbourne Law School with some of the great people who I saw on the call earlier. And so there was a bit of work on that. And then it goes away for a long time. And then I remember like another peak in, I think, 2021, I just moved to China. And thankfully I had a bit of free time, including because it was COVID times. And so then I was doing some further revisions, and then it went away and I didn't hear about it for a while. And then had to come back to it a year later or a year and a half later. And so and even up until last year, very sort of concentrated push on the editing, on the final polishing. So just that sort of cycle of having a project and having it be such a long burn, it can be really challenging, particularly if you're not pursuing like an academic vocation. I mean, maybe it's challenging if you're in an academic vocation as well. But it's a different kind of challenge to make time in your life and in your job to work on your manuscript. So last year, I remember for the final push, I was getting up at sort of 4:30 in the morning and working until 7 a.m. when my kids got up, and then to get ready for work. So that's just that was what was most challenging and most unexpected for me. I also as I mentioned, I took it out of my PhD thesis. And so removing what I think Fung Ling, who's on the call, referred to as the academic scaffolding, which has always sort of stuck with me, that's a bigger challenge than you think. And it's much more difficult and sort of intensive process than I wanted to believe. And ultimately, you just kind of end up rewriting almost everything to really optimize it for the audience and for ultimately the reader, who will have different interests than the previous audience. And so I found, even though I wanted to short circuit that process, there was really no way to do it. And of course, your writing will evolve over time, hopefully for the better. But I found that like my sort of vocation as a writer had changed. And so I was pursuing different styles of writing on a day-to-day basis. And so, you have to be prepared to get back into something that you haven't touched in 2 years and be like, what, this is rubbish. And then rewrite it again. So, it wasn't always sort of, engaging.
So Matthew, thank you. I think I have to say you're the first person in the world, aside from Patim, that I spoke to about this project, and you took you a long time, I know. But I actually think, and I think it's a real sign of a great book, that it did take time, but it's actually really, really worth the read. And I think, and congratulations on its publishing just 2 months ago now. and it is one of the most sophisticated books on Indonesian bureaucracy that exists. In fact, I would say arguably on almost any bureaucracy, because it's taken it seriously. It's taken the challenges it faced really in a thoughtful and really in-depth, nuanced way. And that was part of the challenge, wasn't it? To meet the nuance with the sort of a bigger audience that could understand that nuance. So thank you for that. I know it wasn't easy. I'd like to now move to the second question, and we're going to slightly change up the order. Simon, you'll answer first, and Pamulia, and then Matt, you'll get the tail end, but I'll swap around at the last one. The second question is, why is your manuscript important to the reading public in Australia and beyond?
Well, that's a good question. And I'm glad that Melbourne University Press has already published my book. Because I hope that it is an interesting book, particularly because, as you said earlier on, Jeremy, Australia and Indonesia, regardless of who's the bigger player in the relationship, who the relationship is more important to, we're neighbours, and there's a lot about Indonesia and Indonesia's judicial system that is interesting, I hope, to Australians, whether they be, at the high end, the investors who are thinking of putting some money into Indonesia, or coming a cropper in their dealings with Indonesian parties or the Indonesian government, and kind of find themselves in a dispute. That's on the big end of town side. But then, of course, we also see a lot of Australian individuals getting in trouble in Indonesia, particularly in Bali. So I was kind of keen to provide something that was accessible to a wide audience. And I suppose, and it's not a great or a nice conclusion to draw, really, but it's really about poking holes in the system, unfortunately. So at the big end of town, you've got unfortunately high levels of judicial corruption. I've almost always cited Mulya Lubis's statements about the extent of corruption in Indonesia's judiciaries. I remember him quite famously, in my mind at least, saying in a Tempo interview that he thought about 90% might have been corrupt. I'm not sure where the
long time ago.
Yeah, that's right. That was a long time
Even
ago,
more.
but it might be. Yeah, that's right. But it's not just corruption, of course. We've got quite complicated investment disputes that Indonesian judges, like judges everywhere, may have trouble coming to terms with. And one point that I am really interested in particular is enforcement of judgment. So you may end up with a favourable decision, but then what can you do with it? And I think some commercial entities with arbitration awards are finding it quite difficult in Indonesia to have those enforced in Indonesia. So that's a major problem. And then, as I said, of course, there's the more individualized cases, unfortunately involving drugs, but also murder. I'm thinking in particular of the Jessica Wongso case that I mentioned earlier on. That was, I mean, it became a big story, I suppose, in Australia, particularly after there was a Netflix documentary about her. But I was kind of watching the case unfold, I should say, while I was living in Indonesia during her trial. And yeah, it was a great opportunity to include an analysis of that in the book as well. So people might not know, but Jessica Wongso is a permanent resident of Australia. So again, I would hope that that's something of interest to the Australian public.
Yeah, and I think, I mean, the whole, and Simon, thank you for that. I think the whole series is really trying to show our region, and which is also a reflection of us, warts and all. It's not meant to be just about everything is rosy and, we all love wearing batik, but actually engaging in a serious and thoughtful way. And on that note, I think it's a wonderful opportunity to introduce Pa Mulya for his answer on this particular question about what is really important when reading your book.
Okay, well, let me start by, I'm repeating again and again, that Indonesia is a big country, very rich in natural resources and offer a lot of opportunities. And I've been doing, a lot of legal consultancy for, business people, be it from Australia or from other countries, in order to do business, to invest, and to collaborate in various fields. So anyone has to interact with the governments, local governments, central governments, and knowing what kind of ecosystems they're going to enter into. So this is the problems. When they go into the ecosystems, they might sense there's something that is not really certain. When you talk about corruption, you know very well that corruption is very systemic, endemic, and widespread. We even have and call it, a state capture corruption, where state is being used and misused by the people who are in power or close to power. So an understanding of prevalence of corruption is very important. My book offers an overview of what's going on in Indonesia as far as corruption eradication is concerned. Business people, whoever they are, who want to do business in Indonesia, must understand this. And for sure, they want to have a legal certainty. For sure, they want to have legal supremacy guaranteed in their business. But in a country where legal certainty is not that strong, the challenge is how to navigate business in order not to be trapped in corrupt practices. That is the challenge that everyone is facing. But of course, if you know the right way, if you understand the cultures, there's always ways to mitigate risk. My book offers not only for the business people, but also governments, officials, academic communities, entertainers, and everyone to understand the bigger pictures and to understand also what happened in the field, when they deal with the authorities. So this is an introduction. Of course, it's not easy, but still, I believe they have to again try to connect with the people and understand the cultures and the systems. And I hope they will be able to at least mitigate. I'm saying this because I've been representing quite a lot of foreign investment in Indonesia. In the past, before I served as an ambassador, before I was appointed as ambassadors, when I ran my law firm, 90% of my clients are foreigners. And most of them are very strict and very legal compliance. They don't want to breach the law. And they're bound by, like in US, they're bound by Foreign Corrupt Practices Act. If they come from Europe, they are bound by OECD Convention. If they come from UK, there's a Anti-Bribery Act. So they want us to make sure that they will not breach any laws in Indonesia. But we know very well that there are a lot of problems, despite the fact that we have done a lot of improvement as well in Indonesia. Improvement within the judiciary, improvement within the police and attorney generals. Although lately, I think everyone here, a lot of complaint, a lot of discontent about what's going on in Indonesia as far as law enforcement is concerned. But I'm not, giving up. I think we have to start, making noise. And probably my book is one of the noise that need to be heard by everyone in Indonesia, especially. So,
absolutely.
So this is the things that what I have in mind when I wrote this book. Actually,
it's absolutely it's absolutely an imperative to sort of respond and think about, especially, and we've seen the last 2 weeks with the issues in relation to sentiments in the public about police and law enforcement. Can I ask you one question though before we move on to Matt, which is, what is the biggest mitigation, sort of active mitigation, that sort of a foreign company could engage with if they were entering the Indonesian market?
Well, we are guided by one, law itself, knowing the rules, know the law is very important. But secondly, evidence, we are only guided by those two, law and evidence. If you comply with the law, then you are fine. Of course, it has to be supported by the evidence. So I keep telling my client, my friends, that comply with the law and have your evidence ready. That's what you have to do, to mitigate. I'm not saying that they can, probably get away from all this accusation or probably, abuse of powers. But again, knowing the law and having evidence, is something that you have to keep in mind to mitigate, the risk.
Thank you, Pak Mulia. Now, Simon, you had your hand up.
Yeah, I was going to say, so that the takeaway there is that you consult Prof. Mulia before, not just after.
Yes. Thanks, Simon.
Matt, where does your manuscript fit? What's important about it?
Thanks, Jeremy. Yeah, now, in a previous life, I worked in Indonesia for a long time and advised foreign companies and things like that, and worked with law firms as well, similar to Pat Mulia's law firm. And we always used to joke that if we're calling that had befallen these companies. So yeah, they need to. I think you're totally right, Pat. It's about being preventative and being ready for the phone call or the bad day whenever it comes. What's important about my book to the reading public in Australia? I mean, I agree a bit with what Simon had said. Obviously, in Australia, Indonesia is a big and important country. It's crucial for people to understand in all walks of life and many, many sectors. We need more familiarity with Indonesia in Australia. I think that's something that's only increasing as you mentioned at the outset. Indonesia's economy grows, but also Indonesia becomes an increasingly influential voice just in like regional and global affairs. So it's definitely a sort of critical relationship, and we need sort of more people that have skills and capability and familiarity and people to people links. So I think that's one thing. So hopefully that's useful for people. Thankfully, in the 20 years since the end of the crisis, so I was writing about the Asian financial crisis, which many will know was sort of 98 to 2004. In the years since then, Indonesia's enjoyed pretty impressive economic growth and overall stability, aided in a lot of ways by the work that I look at in my book, I would argue. But a lot of the institutions and the features that contributed to what occurred still are really relevant to governance in Indonesia today. So hopefully that's also useful for scholars, whether it's business people, whether it's people sort of thinking about their own research or sort of challenges. Because I looked at a crisis environment and the way that policies and interventions were like designed to deal with that crisis, I also, hope that is useful for those who are thinking about future crises. Hopefully not in Indonesia, but just crises really in any kind of emerging economy with sometimes like weak governance or political transition going on, all of which was happening in Indonesia at the time. One of the things that you'll see if you read my book is how there was this real tension between the institutions that existed in Indonesia, or in a lot of cases didn't exist in Indonesia, for addressing this crisis, and the idea of what the international financial community and the IMF, really was almost dictating needed to happen. That had a huge impact on the way that the government and the government agency, IBRA, which I look at in my book, the Indonesia Bank Restructuring Agency, was able to go about its work, and ultimately what was able to be achieved. And when various observers or critics or law enforcement or future policymakers have looked back at this period and looked back at what was achieved, that is sometimes with some criticism, but a lot of that is related to this, the design ultimately of the intervention and of the financial sector rescue package, and the conditions that were imposed on the government of Indonesia by its creditors and by the international financial community. In a way that a lot of Indonesians, and I have a lot of sympathy for them on this, feel like was a real sort of almost violation of not just the policy space, but sovereignty in a way, and that it wasn't really sort of targeting the root causes or what was necessary to stabilize the crisis, but it was really targeting as well like the political economy of the Suharto regime, which was brought down during the crisis. And so hopefully it's useful to people who think about the next crisis, wherever it is, and how do we sort of design interventions or rescue packages. And just following on from the final point is that the book does really go under the hood, as I think you said, Jeremy, in kinder words, but then thank you for that. It really goes under the hood of like a real life policy implementation conundrum, and it tries to show how you can do really like detailed political economy and economic history using like original research and like deep documentary evidence in a way that connects to like broader institutional theories, and so on and so forth. And so I think that is useful. I think it's also, it doesn't just focus on inept institutions or bad governance or corruption, all of which are sort of factors and things that, even in my sort of slice of research, I can't rule out all of these things as being factors and indeed being decisive. But it does look at the way that things were accomplished and the way that policies were implemented, and it's important to track those things as well, because it's I think it's quite useful as an explanatory factor, but as also sort of situating things in a broader political context. So hopefully I did that in the book as well, and that's something that readers are able to access.
And thank you, Matthew. I think it is not just for Indonesia a really worthwhile read. This is for all developing economies, and I would actually say for our public service a well-worthy read too, because actually managing and dealing with a crisis in a thoughtful and considered way, and this was a crisis with a really capital C. It wasn't a minor ripple through the Indonesian economy. It was potentially going to collapse the finance sector, and that's and managing such a problem is something well worth learning from. And I think the Indonesians did on this case exceptionally good job given the circumstances and the issues that we're facing. Now, the last question I'm going to do for the three speakers is, and I'm going to read it firstly so the speakers can remember it, start to process their answers and then get ready, and then I'll go through the order. If there was one uncomfortable truth that your book reveals about law and society in Asia that many scholars, policymakers, or the public would prefer not to hear, what is it? And I'll start with you, Matthew, then I'll move to Parmulia and Simon. So if there is one uncomfortable truth your book reveals about law and society in Asia that many scholars, policymakers, or the public would prefer not to hear, what is it? So Matthew, the floor is yours.
Thanks, Jeremy. Yeah, so I think, I started to touch on it a little bit in my previous answer, but, you know, policy implementation is really messy. Is kind of the key takeaway, or one of the key takeaways. Like, institutions are not perfect, probably even in the best case scenario, let alone during a really like existential, or as I think I say in the book, cataclysmic financial crisis that's taking place at the same time as a pretty chaotic transition from authoritarian political system to a democratic one. And so institutions are never perfect. There are also political contests that are going on around almost every single policy implementation process. And they're not always just about competing visions of how to get the best outcome. You're lucky if that's what they're about, but they're usually about a number of other things. And, one of the things that you see in my book is that often the biggest challenge to going out and accomplishing the tasks that were set out into the bank restructurings that I look at in the book is coming from within the state itself. So it's contests from different areas of the state that are almost like constraining the state greater than sort of any of the other factors. The other thing is just a lack of realism. I don't know if it's intentional or not. Sometimes it's probably both, about what government can actually achieve with the tools at its disposal. Right? We think of government as like really powerful and able to get outcomes and things, but you really have to actually and in this case during the financial crisis, the Indonesian government was really constrained by like a span of factors, some of which I mentioned, but they were like fiscal constraints, right? They had no money, and that led to the decisions that were made about the policy response and the fact that the government was going to pursue something called asset settlement with the owners of the private banks that it had nationalized during the crisis. And so that essentially meant that government was willing to trade off, you give us some assets and we'll release you from your legal liability for the potential fraud that happened at your bank. That meant we had to take it over. Also, the international factors, which I mentioned, IMF, international creditors, they had their own ideas. And then there's just this ongoing political churn, right? So there were numerous presidents, numerous chairs of the agency, IBRA, that I looked at, disagreements between law enforcement and bureaucrats about not just about what was agreed, but about what legal instruments were even sort of appropriate for agreeing these things. And so I look at all these things in the book. And so, things are never clean. It's never sort of possible. And then the final thing is just that financial crises are really expensive. And the government is the only entity with the balance sheet and the legal credibility and the control over the legal environment to come in and sort of step in and try to stop the bleeding, or at least stent the bleeding. And that ultimately costs money. It ultimately usually ends up with those who caused the crisis or those who are responsible for the financial institutions that, caused the crisis, they don't usually end up getting like dismantled, because that's an even, bigger problem and challenge. And you look across all sorts of economies, whether it's Indonesia, whether it's the US during the global financial crisis, and there is almost always this popular discontent with the fact that bankers got away, the losses were not fully allocated, and really that's just kind of the reality of a financial crisis, is that it costs money, the financial sector has to get bailed out, and therefore the people that ordinary citizens and the public think are responsible usually end up sort of getting sort of bailed out. And so that is really some of the core of the criticism of the program that I looked at in my book. But I would say that kind of almost misunderstands or misses the point about how this process was designed, this like asset settlement concept where former bank owners give the government assets and then the government lets them go, basically. That sort of simplifies it, but that's sort of what happened, and that can be very hard, right? If you're just an average citizen, that seems unfair, right? But it's what happens, and actually, I would say that the implementation of that in the cases I looked at went better than many people would have expected.
That's it. Matthew, I think that's a really valuable contribution, the sort of messiness that we don't like talking about. It's in some ways how the sausage gets made. You like the taste, you don't want to know what goes in. And that's true in Indonesia. It would also be true in Australia if you looked at our responses to the 2008 sort of meltdowns that were occurring elsewhere, where the response was on the fly, very quick, and messy would probably be the best way of describing it. So thank you for that. Just one thing, there's been a question already put up onto the question and answer board, but if you have a question, don't hesitate to put it up on the board. And once we get to at the end of both Pa Mulia and then Pa Simon's response to this, we'll move to your question. So Pa Mulia, what's your uncomfortable truth?
All right, this is a very good question. What is one uncomfortable truth that my book reveals? But before I answer that, let me give you some background, because I think this is important to do that. As I said earlier, corruption is very endemic, systemic, and widespread in Indonesia. And Indonesia was one of the most corrupt countries, especially under Suharto time. Our corruption perception index is worse. But when we have reformasi back in 1998 and 1999, the new governments campaigned to have a clean government. Combating corruption became a #1 agenda of the nation. KPK, or Corruption Eradication Commission, was set up. So it was at that time KPK start their work going after all these most corrupt individuals, be it from the governments or from the business communities. And we are lucky because the KPK was led by people with integrity, people with good reputations. And I think KPK succeeded in their campaign. For the first 15 years, I believe KPK did a good job. Never in our history we have so many ministers, member of parliaments, governors, bupati, or even the judges from the Supreme Court, Attorney General's office, caught by the KPK. So this is quite unprecedented. Speaker of Parliaments, I forgot to mention that. So why KPK succeeded? Because they have all the powers. We call them super body at the time. But as I said earlier, starting from 2019, KPK was weakened. Now, why KPK was weakened? Because at the end of the day, if you keep the KPK strong, powerful as a super body, they will go after the power themselves. They will go after the authority. So what is lacking here? What is lacking is the ideology of rule of law. The ideology of rule of law is very weak. Yeah. So the notion of independence of judiciary is not really rooted in our country. If we read 1945 constitutions, I don't think that guarantee the independence of judiciary. Now, the process of weakening KPK come from the palace, come from the ministers of cabinet, come from the member of parliaments. That is what I call uncontrovertible truths, that I reveal. Those who are known to be, people who supported corruption eradication, but they're the one who weakened the KPK. And when you go up to the list of corrupt officials that's been caught by KPK, there are a number of politicians, number of businessmen who are known to have integrity, who are known to have good reputations. But power is so tempting. Power gives you opportunity, and then they end up being a corrupt, officials as well, and sent to jail by the KPK. I know some academia, some people who led the Indonesian Election Commission, some people at the Judicial Commission. Well, I believe they are good people, but I don't understand why at the end of the day, they are also committed, corruption. How come, after so many years practicing as judges, as a member of parliaments, as a bureaucrat, then you sacrifice your life, you tainted your legacy. In fact, they don't have legacy. Sometimes I thought, well, not all people perfect. They have good intention, they have good mind, very smart people, but power is so corrupt.
It's a poison apple, isn't it?
It's an opium. It's an opium. So that's the unconvertible truths that make me very, very disappointed. And in a way depressed. Knowing that. And I've been mentioned as potential attorney general at one point, and I could not imagine if I become attorney general. I will go after my friends. I will go after all these people who I know, as good people in the past. Probably that is probably my answer, Charlie.
No, it's an absolute truism. That is one of the most challenging things when it's not bad people, when it's good people, that makes it so much harder. And I think that's actually the really uncomfortable truth about it. How do you protect and support good people to do the right things? It's not easy. But thank you, Bumble. That's a really challenging question. Now, a response. Pa Simon, your response to this question.
Well, a lot of what I was thinking of saying has been covered by Prof. Mulya now, but I suppose my kind of most uncomfortable truth is that, or that's kind of raised by the book, is that there's no silver bullet for judicial reform in Indonesia. After I've spent quite a long time, explaining why the system is dysfunctional, I'm often asked, well, what's the solution? And the question, I just don't know how to answer that question. I remember the late, great Dan Lev joking that perhaps you needed to bomb the Supreme Court building and start again. So you kind of sack everyone and then start afresh with a whole bunch of new judges. I know he was only talking facetiously there, of course. But the problem is, and this may kind of tie into what Prof. Mulia has just mentioned, you might create new institutions. In the book, I kind of look at specialized courts, so new courts that might be tied to existing courts or independent from the judiciary, other branches of the judiciary, I should say. But and for a while, it can work, but over time, leakage starts to occur. And some of the broader problems in the judicial system start to emerge. So I look at specifically the anti-corruption court and the constitutional court, both of which I say are specialized courts, even though it might be a bit controversial to call the constitutional court a specialized court. But in both cases, they start pretty strong. And then over time, their opponents start taking pot shots at them, and eventually some of them start to land. So for the anti-corruption court, we have a constitutional court ruling which requires new legislation. Previously, only KPK prosecutions could be heard in that court. The new legislation allows prosecutors to get involved as well. And so then you have the first round of acquittals after 10 or 15 years from those courts. Now, whether or not having a 100% conviction rate is a problem, I'll leave for another discussion. But certainly after that point, you have more acquittals. Then there are lots of trials for corruption of anti-corruption court judges themselves, all of which I talk about in the book. And then there's a few other kind of steps along the way of the story as well. But now I think you see the government's control of or maybe more the president's and the inner circle control of the Attorney General's office. And because it has power to bring these corruption cases, I think it's fair to say you see an increased use of the anti-corruption infrastructure to target political opponents. So the weaponization of anti-corruption, the anti-corruption movement, I suppose. So it's almost like we've come full circle. Initially, we have these new reforms introduced to make anti-corruption enforcement more transparent, accountable, independent. And now you have the whole process co-opted and being used actually as a weapon by politicians rather than holding politicians to account. And of course, when it comes to the Constitutional Court, when it was established, some were suggesting it should be part of the Supreme Court, not its own institution. And of course, that didn't happen. But if it had, I could imagine that the success of the court, at least initially, would not have been so impressive. If it was tied to the Supreme Court, as Sebastian Pomp refers to it, an institution that had collapsed, then perhaps its initial history would have been very different. Of course, now we see that court too marred by very similar problems to the anti-corruption court, in the sense that some of the judges on that court have now been found guilty of quite significant corruption, but we also see kind of nepotism rearing its ugly head in the Constitutional Court as well. Now, it's easy to say, well, these are the problems, the leakage occurs, these courts operate within a system that encourages corruption and doesn't reward integrity. Everything is stacked against individual judges. You have to make a lot of compromises to be clean. But the problem is, well, how do you fix it? And I just don't have an answer to that question. Every single thing that I think of or that people suggest will fail in some way. And so that's my uncomfortable truth.
And I think that's actually really interesting, Simon, that in some ways what your answer arcs back to is what Pamulia said, which is that until the underlying principles, social cultural values change or solidify in a certain way, all the legal maneuvers you have only have a certain veracity. And I think that's really does the rule, the idea of the sort of getting traction for the rule of law, as Parmulia said, is kind of some ways.
Yeah,
It's a very hard thing to say and to do, but it's the.
but the problem is we're not heading in that direction at all now. You know, when the institutions that Mulia and I write about in our books were at their peak strength, it was hard enough. Now that the momentum seems to be pushing back towards, or moving back towards some form of repressive, not particularly democratic government, it's even harder to instill those values or foster them.
This is such a challenging issue, and it's a great place to move on to questions from the floor or the Zoom. I'm going to take it in batches of 2 just for ease. The first question is actually to Parmulia, which really comes out of I'm paraphrasing, a Tempo article about the recent corruption investigation into the Ministry of Education, Culture, Research and Technology, in which there has been a they talked about there being sort of a competition between the Attorney General's office, the Jaksa, and the Anti-Corruption Commission, the KPK. Do you want to do you think there's a rivalry and how would you respond to it? And just before I move on to your response, Parmulia, I'm going to give the next question so that we can deal with it straight away, which is from Joel, who asks, how does your work, for people who aren't deeply engaged in, the average Australian or the average Australian academic, how do you, and this is for all of the authors, how do you make your books speak to that broader audience? So Parmulia, we'll start with you about the competition, and then we'll move to the broad audience question immediately after that. Parmulia.
Well, the case of Minister of Education, former Minister of Education, Nadhim Makarim, is very interesting. For me, I don't see Nadhim is enriching himself. He comes from educated family. He comes from a wealthy family. Yeah. And I don't think he needs money. He is also a founder of Gojek.
Yep.
Yeah. So to speak.
He doesn't need money.
So, because the definition of corruption is if you do an act, unlawful act, enriching yourself or enriching the others, yeah, be it individuals or companies at the expense of the state laws, that is corruption. So I don't think Nadhim, is enriching himself, and probably the allegation is he may enrich corporations, yeah, that provide or that support the project, yeah, buying the Chromebooks. But my reading is, it is a policy. It is a decision that was deliberated and made by ministers as ministers. And policy cannot be criminalized. This is my point. Yeah. So if you criminalize all this decision, yeah, made by the public officials, then there will be no people wanting to be public officials. I mentioned this because this is not the only case. There was another case, recently, former Minister of Trade, Tom Lembo, he was also criminalized. Before that, there was the President Director of Pertamina, Karen Agustiawan, who was also criminalized for her decision, despite the fact that every corporate approval has been issued, to support her signing of contract with Corpus Christi in US to buy the LNG. And there was Lin Chi Wei. There's another one, Hotasina Baban. So there are so many people criminalized for their policy. Even former Vice President Budiono was accused of corruption, yeah, at the time for saving Bank Senturi. But I thought Pak Budiono saved Bank Senturi because he was afraid, he was worried that if something happened, then there will be a rush. There will be people going to the bank, taking back their monies, So that would create a lot of chaos. So my take is on a Nadhim Makarim case. yes, this is a policy that cannot be criminalized. But the question is there a rivalry between Attorney General Office and KPK? To me, it is not only a rivalry. Attorney General Office is in the process of taking over corruption eradication from KPK. All big cases now at the Attorney General Office, not at KPK. So in the past, there have been also a discussion or discourses whether KPK is a permanent institution or not, whether KPK is an ad hoc, institutions. And I think this is what they have in their mind. Probably slowly, and surely KPK will be probably dissolved, in due time. I hope not. People are still supporting KPK to a certain extent, but people are also disappointed with KPK. So this is my take, on Nadiem Makarim, on the rivalry between Attorney General Office and the KPK. So your second question is, okay, well, I love my book to be read by wider audience, not only in Australia, because this is published by Melbourne University Press, but I don't see the book is being sold in Indonesia. And secondly, I think if the book can be translated into Indonesian, that can be used as a reference in the Faculty of Law and can also be distributed to other agencies that deals with corruption. I hope I answer your question.
Yeah, no, it's a really good point. The distribution is a really important element of getting that information, and is translation. And I wanted to say something on this point because I think it's really important. One of the really big priorities of this book series has always been to publish voices for the region, such as Bapak Mulya's book, and to do that. The importance of that isn't just in itself to have MUP publish Pak Mulya, but also Pak Mulya's voice to go right into the region, and that's something I think a really important point. Thank you for making it, Pak Mulya. Simon or Matt, would you like to respond to that question about how do you sort of broaden the access, and especially for people who have relatively low base knowledge? Simon? Matt, you can go. You go for it.
Can I go?
Yep, please do.
Sure. I mean, before I get to that question, I just on this question of criminalization, I also just want to touch quickly on my book, which includes an example of a case that I would say bears some of the markings of criminalization. For a former head of the Indonesia Bank Restructuring Agency called Syafruddin Temenggung, and this. He was convicted twice and then acquitted on appeal at the Supreme Court. And the first case the KPK ever lost, actually. So the end of the 100% conviction rate. And this was related to a letter that was issued basically under the auspices of an impress, and I won't bore you with sort of hierarchies of Indonesian law, but the president had decided and had consulted the parliament on the way to resolve these contracts that had existed between the government and the bank owners, and so they decided they would release these letters that would that the IBRA chair would sign, and that would basically say that the contract had been sort of discharged, and what was in the contract, which actually already included a legal discharge but had not been respected by law enforcement, would sort of be acknowledged by the government going forward. And those letters were taken to the FSPC, which at the time was the Financial Sector Policy Committee, which included all the sort of major ministers of state. It had also gone to the State Enterprises Minister. So this was a policy decision. But because the recovery of funds under these contracts had been less than what had been the cost of the bailout to the government, which, by the way, these contracts were never designed to do that, that was a state loss. And therefore, that was what this case unfolded on, because of their very broad definition under corruption law of anything that causes a state loss can be under the Act And so, it's just very interesting, that sort of observation about how policy decisions, like in the sort of context of the corruption law and in the context of the policy process, can then lead to criminalization of the person who made the decision. Looking into all the sort of background of it, I sort of found that somewhat problematic for some of the reasons I mentioned. But it's another thing that is in the book if you're interested in this issue of criminalization. That there is this very, I would say, rich example in the book. So just to sort of put in a plug for that there. On sort of broadening it and making it accessible, I mean, that's quite a good question. I don't know. I'm not sure. I discussed a bit at the beginning, taking out the academic scaffolding and how much of a challenge that is. That it really takes a lot of work, and it's something that you have to think carefully about. There were basically entire sort of chapters that I thought were going to be in the manuscript that were ultimately lost or condensed into very sort of short, sharp passages. So think more about, what did you observe? What did people say? What is in the primary sources that you're using? And then what does it mean in the broader context? And much less about, theoretical frameworks or, kind of academic ideas. That was what I found to be the most sort of important thing to do. I don't know if I succeeded, to be honest, because this is the first and potentially only book that I will have written. But it was quite a worthwhile activity, because I think now I have friends and family who are reading the book, and they say things like, "Oh, it's accessible." They sort of enjoy it. They enjoy the pacing as well, and that's just not possible if you're trying to sort of talk about your sort of 10,000 word literature review. So you have to just take all that out, really, which is hard if you're coming from a scholarly or academic background. So I think we all are in our own way.
And I think it is, and Matthew's exactly correct. It's very hard to, number one, create a text which is it's accessible, but also takes out a lot of the jargon which we as scholars or specialists in a particular area, such as Indonesia or China or whatever, engage with as if it's normal and natural language. And that's sometimes the challenge, is to sort of, when we're contextualizing it, is how do you provide a semantics which is legible, understandable to your audience. And it's great. It's really one of the real challenges we have in the series, and it's, I think, really been, I mean, Matthew put in a super huge effort in getting it to that stage. Simon, how do you make it accessible?
Well, before I get to that, just a point about the corruption prosecutions and criminalization. One of the problems that's been around for a long time in Indonesia is the definition of corruption, which doesn't require criminal intent. It just requires that you perform an act which is in some ways reprehensible, and that could be ignoring a policy or even taking a policy that might have a problem with it, and creating loss to the state. And that's it. And so it's an enormously powerful tool for people or politicians in particular, to have at their disposal to take out political opponents these days. And I think that's part of what may be behind the rivalry between the KPK and prosecutors. Even though I suppose now the KPK is formally part of the executive in any event. And so that also goes to the question is, well, what point of distinction does it have from the ordinary prosecutors now anyway? A very, I think, important plank in the argument to maybe disband it, which is what Prof. Mulya was talking about. But I just wanted to emphasize this idea that the corruption law itself is just so easy to use. And quite apart from anything else, corruption cases are pretty wet butter for prosecutors. They're quite notorious for, having defendants that might be willing to try and bribe their way out of trouble. after all, they have been accused of corruption. If they have, you could expect that kind of behaviour, I suppose. But also, Attorney General's Department, JAXA, have performance indicators, so corruption case targets that they try and meet. And so, there are other incentives at play here as well. So there's a whole lot of stuff going on. As for making my work more accessible, I did put in a couple of sex cases, which I thought might appeal to the grade 4 student that Joel mentions. No. Look, I tried to write in a way that is accessible by talking about cases. I mean, Matthew's also talked about kind of discussion of cases, and I know Mulia's book is full of real cases as well, which I think brings the story alive to a reader. I don't think you could say that any of the 3 books here are too theoretical and dry. But I guess the other point, reading Joel's question, which was, well, how do we make this relevant to an Asia illiterate audience, perhaps, if that's part of the audience, is, well, I'm not sure whether we should apologize for writing something that is, specifically about a country. We can write as clearly as we like and try and engage the reader. But, once we've done that, I think it's partly up to the reader to deal with that. The question of how much they absorb. I mean, there's only so much you can do as a writer without dumbing it down so much that it has no benefit to your actual target audience.
And so that's really a very valuable point. It's very, I mean, one of the things that we're trying to do with the series, and Rehan asks what is different about this book series to other sort of book series on Asian law and stuff. Well, one of the big differences is starting it by centering it in Southeast Asia and moving outwards. But also in our really clear attempt with MUP to try and make this as accessible while not losing the sort of significance and substance of the material. And that's a very, very big challenge. This is not purely an academic series in which Simon is only talking to scholars of, constitutional courts. We do want this to be a bigger part of the debate and dialogue. And to be very honest with you, one of the reasons that I've done this and I've spent a long time doing this is not just because I want 3 wonderful authors sitting around me, but also because actually this is about engaging public debate. But you can't dumb that down totally. You can make it accessible, but you can't necessarily dumb it down. There are complexities to interactions between players. There are complexities about what corruption means or what it doesn't mean, or how you engage with ideas of rules of law. So that's my 2 cents worth on that. So thank you all to the authors. It is really it's a hard issue. I've got a question from Eddie Atmajaya, who asks, and this is really sort of directed to you towards you, Simon, but I'm sure others will have a take on this. Is the problem with like law enforcement in Indonesia, is it really we're talking about a sort of a take on feudalism? Is this, about the sort of figures of prowess, sort of the attorney general or the sort of, authoritarian, sort of police chiefs, etc., etc. Is this sort of about, and you see it in the Philippines as well, the big man, sort of the big sort of man, sort of leader, the sort of boss politics. Is this what we're talking about? Is this sort of almost unavoidable?
Yeah, I suppose it is in some ways, and it's getting more so in Indonesia. The last part of the comment is, what do you think? And I guess what I always find disappointing is that, sure, you may have a prosecution very closely associated with the state, becoming more so. But at least constitutionally and legally, you still should have an independent judiciary. right? So that's, I mean, that's still enshrined in the Constitution, in law. And so the Constitution, the Constitutional Court says it all the time, but other courts do too. You know, we are the bulwark between the state and the citizenry. So we are there to enforce rights and keep the government from intruding on the rights of citizens. So yeah, I don't disagree with the question or the direction of the question, but it just, to me, always underlines the disappointment that I have with the Indonesian courts almost on a daily basis for not doing their job, which is not supposed to be part of these institutions.
Would anyone else like to add anything, Pamulia or Matthew?
Well, Matthew, you go first. I'll go later.
No, you please go. Pamulia. Yeah.
Well, I think I agree with Simon, you know, but what I'm seeing also lately is not only within the judiciary, but within the government as a whole. The authoritarianism, feudalism is emerging, yeah, very obviously, yeah. So I don't understand why the military now is assigned to guard the Attorney General office, to guard the all prosecutors' office in every city. So this is very disturbing. When you're talking about independency of legal profession, be it prosecutors, be it the police or the judiciary, then I don't think we need such kind of engagement. But that has been assigned, and every time I go to the Attorney General office, because I pass that office every day when I go to my law firm, and I saw the military officers guarding the office. So that is disturbing, and I think in a way that would affect the independency. Yeah. So when President Prabowo came to power, when he formed the cabinet, he brought all these ministers and head of state agencies to Magelang, and all of them wore a military uniform. When you have the second Pilkada, the regional election, the same thing happens. So when you talk about feudalism and authoritarianism, yeah, this is what worrying us, yeah, at the moment in Indonesia. Yeah, Simon also talked about weaponizing the law by the law enforcement agency, and I think the trend is to misuse and to abuse the law itself, you know. So that's why we are now trying to do a lot of judicial review, challenging, you know, some of the articles within, let's say, corruption eradication law or the law on KPK, yeah, because there have been a lot of loophole, yeah, used by the law enforcement agencies to criminalize people, yeah. And the fact that legal reasoning is not really there, you know, as a tradition, because legal reasoning is very weak, yeah. So they just go after the law, you know, after the articles, words by words, and not, you know, seeing, you know, or not considering the past judicial decision or jurisprudence, yeah. So everything is based on the narrow interpretation of the law itself. Yeah, so that's what happened, and I think that is very dangerous.
Matthew?
Thanks. Yeah, I mean, I don't really, like, I don't feel super qualified to answer this, and also, like, important to emphasize that, like, I wasn't working that much on sort of contemporary Indonesia. Like, I was working on 97 to 2004 for the most part. And then I dipped back in a little bit to a contemporary corruption case that related to something that happened in 2004. But one thing that I did find was that, you know, in some cases it wasn't I think it's important for us to I think it's important for us to remember also that Indonesia has been a democracy for a very short period of time, actually. And what came before was a really sort of like extensive authoritarianism that had very sort of like deeply ingrained institutions and institutions that did not exist like above ground. There's like a lot of scholarship of the kind of like late Suharto era about these like the informality in the state, the sort of institutions that were not observable or only partially observable. And so when I was going through my research, some of the things that amazed me the most, and I was just frantically looking for it and I can't find it, but there's a quote from Tim Lindsay and some of his scholarship that's in, I think, my thesis and maybe even the book, about how the late New Order was this like highly elaborate, highly sort of formal, hard law, but what really existed was kind of none of that. And so I frequently found times where, you know, there wasn't really actually even a law for what you would think is like a sort of critical issue. Or you could have a situation where contracts, which were the contracts that were signed in '98 with some of the bank owners that I ended up looking at in a few of my case studies, the process was recommended by the Attorney General, who had led a sort of intergovernment process to determine this. And then at the last minute, the Attorney General didn't sign the contracts. And so they had to be signed by the IBRA chairman on behalf of the Ministry of Finance. And then eventually, when it came time to you know, resolve all these contracts and almost like you know, adjudicate the disputes between the different state agencies and law enforcers about their status, they used an impress, which is a presidential instruction, which has a very unclear status under Indonesian law and is another holdover of the sort of Suharto. So even though we sort of think about like this highly sort of formalized, highly kind of legalized polity, sometimes that's not always the case, and there are actually holes all over the place, and they reflect, you know, the history and the political context and sort of what came before, and the fact that institutions and governance has really only been being built in Indonesia in at least a democratic context for a very short period of time. And so, you know, looking back 20 years ago when I was looking, that was what struck me the most, was how there were all sorts of sort of holes in the system, and it could be exploited, but could also just create unintended consequences where no one was really sure what to do, or they could sort of like legitimately disagree about what the right thing to do was and who was right. And it almost needed like a higher authority to adjudicate almost everything. And of course, you know, when in an authoritarian system, and particularly in the Suharto system, that was the way it worked. So I think, yeah, that was what I found. But you know, that is not really a contemporary issue, at least not anymore, which makes me feel old.
I'm gonna thank you for those wonderful answers. I know there's more questions, but I'm gonna wrap it up with one last question that we'll do whip round to the three authors, and then we'll move on. But the last question is, given the sort of weak state of the rule of law that's been discussed by Pamulia and also by all the other speakers, what would be the one priority, the sort of one reform that you would prioritize to try and give some underpinning to that rule of law notion?
Okay, well, let me start. When we amended the 1945 constitutions, yeah, I think we did a lot of good things. You know, we came up with quite comprehensive constitutions, and actually giving independency to the judiciary. And we set up also the Judicial Commission at the time. And I think the Judicial Commission is very important, but the function is not very, clear, yeah. Especially after the Constitutional Court at that time weakened the Judicial Commission. So if there's an amendment to be made, re-empowering the Judicial Commission is important, because what happened with all this judicial corruption mentioned by Simon cannot be mitigated, cannot be corrected if you don't have a strong Judicial Commission. Now, Judicial Commission job or task is only selecting judges and submit that to the Parliament. I think that's not enough. I mean, they should be empowered to go after the judges, because there are so many decisions by the judges that breach the law, against the law, and can be considered actually, corrupt, in many respects. But the Judicial Commission can only go after ethical violations of the judges. But how could you draw a line between ethical violations and the substantive violations of the judges in issuing a decision? So that is one thing that I would like to, underline here. But aside from that, I guess the strong national leadership that is needed. Yeah, you have the law, you have the constitution, you have all these institutions of law. But if you don't have a strong leadership that is committed to the rule of law, ideology, there's no way we can have independency of judiciary, or law enforcement agencies.
Wonderful. Thank you, Pak Mulia. Simon, what?
I agree with everything that Pak Mulia said. Although this does go to my uncomfortable truth, right? I mean, I say there's not really that much that, I don't know how to fix the judicial dysfunction problem in Indonesia. I suppose one approach is to make sure, or to do all we can to prevent further backsliding. So I'm thinking specifically about really what is the only beacon of hope remaining on Indonesia's legal landscape, which is the Constitutional Court. Now, it has its problems for sure. I've already mentioned a few of them. And there are real problems with co-option by the regime in some cases. But still, there are examples of independent judicial decision-making. And in the face of kind of open attempts by the government to defy the court's rulings, people have kind of taken to the streets and forced a turnaround. So this isn't a solution, but more about what, something we should focus on just to make sure that matters don't get even worse. Because without the Constitutional Court, I don't think there's any prospect for the rule of law in Indonesia for many, many years.
Wonderful. Thank you. And Matthew, do you have anything that you'd like to add to that sort of reinforcing of the rule of law?
No, that's okay. I think my co-panelists covered it quite well.
Wonderful. Look, thank you. And I know that we could keep going for a long time. These are real. There's a depth of issues and a real sort of, and like I said, there's an issue of how you provide an underpinning in sort of a legal environment which is in massive transformation on any given day. And given that there has been the sort of issue of an illiberal turn in Indonesia, as in many other parts of Asia, this is really sort of an ongoing issue. And thank you to the panel, to the three authors, for number one, contributing fantastic manuscripts to the series, and also for putting up with me pushing you sometimes when I think you didn't want to make it any more accessible. But I think it really has made the series wonderful. And on that note, I'd like to move forward to our publisher, Funling Kong from Melbourne University Publishing, and to welcome her to the sort of Zoom, to the forum, to sort of make some remarks.
Selamat tengah hari dan salam sejahtera tetamu dihormati. Terima kasih untuk peluang berucap hari ini. So thank you very much for the opportunity to be here today to celebrate MUP's Asian Law and Society series, edited by Jeremy Kingsley, a series that we're very proud to publish. I also want to acknowledge and thank the authors Mulyo Lubis, Matthew Bush, and Simon Bird for entrusting MUP with their books. Some of you have only met for the first time today, so hello. So thank you very much for the valuable insight into the creation of your books, some of which started before I began at MUP too. And Matthew, there's never any need to beat yourself up about how long manuscripts take to get to publication, because really at the end of the day, there is no better editor than time, I have to say. So on publication in Indonesia, I just want to quickly address that as well too. We hope that the new MUP series infrastructure on our website will improve discoverability for your books. We have tried to sell rights to Southeast Asian and also to Indonesian publishers. There are no takers yet, I guess chiefly because also of the costs of translation. It's an expensive business translating as well too, but we will keep trying. And in the meantime, your books are available for sale, through our website and through bookshops. And also they're available via open access through JSTOR's Path to Open as well too. Now, these three titles we're launching today have a very strong Indonesian focus, and I think we can all agree that it is time that Australians understand better our most populous regional and closest neighbour beyond the shock and awe of geopolitical instability, crime, and natural disasters, and to understand also the nuances and complexities of the issues that matter in a rapidly evolving multi-ethnic archipelago. The series will branch out to examine other countries in the region. Next year, we will publish Anisul Rahman's book on the social construction of marriage in Bangladesh. Thank you, Jeremy, for that. And also, we're ever on the lookout for titles to add to the list. So please send Jeremy and his advisory board or MUP your proposals. Books in this series have been tightly curated by Jeremy, the product of rigorous editorial conversation and also painstaking editing by all of us here at MUP, so they reach the widest possible audience within and without the academy. Readers follow stories and people, and your use of case studies brings to life your argument. So I never see making a work accessible dumbing down. I think it's simply making the work accessible and bringing as many eyeballs as you can to the work as well too. Now, besides this series on Asian law and society, MUP is also very proud to have titles in the Asia-Pacific Islamic Studies and Defense series, which speak from and to the Asian region as well. These complement our other series on Maganya Indigenous, contemporary Australian writers, colonial Australian culture, and a forthcoming series we are setting up on civil society and democracy, and also one on truth-telling. We plan to keep adding series to our list to help researchers and scholars with their work. It is always a privilege as an Australian by choice to acknowledge that MUP books are made on the lands of the Boon Wurrung, the Wai Wurrung, and the Wurundjeri peoples, and to pay our respects to the original custodians of the unceded lands and waterways of the Kulin Nation and across this nation on which we live, work, play, learn, and call home. Working at a university press, we're fortunate we get to learn from and work with Indigenous colleagues and peers. We thank them, and we pay our respects to all elders for sharing their knowledge, just as I thank you for your time today. Semoga kita bertemu lagi. Terima kasih.
Sama-sama. I wanted to thank Hunling for and also for being a really big supporter of the book series, because we know how challenging the publishing times are, and that requires a level of partnership between the publisher and sort of the academic world and the sort of scholarly world in ways that I don't think past generations would have needed. And I think that is in some cases a hardship that we bear, but in other cases it's a real blessing. And it's a blessing to sort of be able to make, and I think really importantly, to try and make our books speak to the public debate in Australia. And slowly we'll keep chipping away at it and pushing at the boundaries, because I think it's an incredibly important contribution here and elsewhere in the English-speaking world, which and I was speaking to one of my close colleagues, Rehan, that we often in law schools are too monocultural. And this is one of the ways that we can really challenge that monoculture, that, you know, we don't live in a world of just English speakers. We have, you know, our Indonesian northern neighbors of 280 million, India, China, that are incredibly important and influential in our regions. I want to end today's wonderful launch with some comments by Maria Batty from Western Sydney University Law School.
Thank you so much. So just on behalf of the organizers, thank you for joining this webinar, Law and Society in Indonesia, which has launched this wonderful MUP Asian Law and book series. So we'd like to warmly thank our partners, the Center for Indonesian Law, Islam and Society at the Melbourne Law School, the Asian Law Centre, Melbourne University Publishing, the School of Law at Western Sydney University, the Centre for Asian and Pacific Law at Sydney Law School for their collaboration and support in making this event possible. So today's thoughtful discussion has really highlighted that Asian law remains vital for Australia, not only just as an academic field, but as Jeremy has noted, a practical lens for understanding how socio-cultural change and legal reform shape one another across the region. So recognizing this two-way relationship helps Australia strengthen legal and cultural connections with its neighbours and better understand the forces shaping our region. So we're especially grateful to Melbourne University Publishing for their support, to all the authors, the contributors whose scholarship have actually made this event possible. And it's really showcased the depth, diversity, and the significance of this field. So finally, a warm thank you to Associate Professor Jeremy Kingsley for his leadership in bringing us all together. And if any of you are interested in building on today's conversation, please reach out to Jeremy via email. And thank you again for this opportunity to attend this wonderful event. Thank you so much.
Thanks, everyone, and have a wonderful rest of the day.
Thank you.
Thank you.
Bye.
See you later. Bye-bye.